What evidence do whistleblowers need to prove retaliation? Imagine doing the right thing at work and then facing pushback or punishment for speaking up. That's what retaliation is all about, and proving it can be tricky. So, what kind of proof do you need to show that your employer punished you because you blew the whistle? Let's break it down. First, you need to show you engaged in protected activity. That means reporting illegal or unethical conduct, like safety violations or fraud. Next, you must prove your employer knew about this report. Having records like emails, complaint forms, or notes from meetings can help establish this. Then, you need to demonstrate you suffered a negative employment action. This could be being fired, demoted, given a bad performance review, or having your hours cut. The key is showing the action was adverse enough to impact your work or reputation. Finally, you have to connect the dots. You need to prove that the protected activity was a contributing factor in the adverse action. This is often done by showing a close timing between the whistleblowing and the punishment. For example, if you report a safety issue and then get demoted within a week, that timing can suggest retaliation. Direct evidence is the clearest proof. This includes emails, memos, or statements from supervisors that explicitly say the retaliation was because of your report. If such direct proof isn't available, circumstantial evidence can help. This might be a sudden change in how you're treated, like being excluded from meetings or given negative reviews shortly after reporting misconduct. Witness testimony can also strengthen your case. Coworkers who saw the retaliation or heard about it can support your story. Keeping detailed records is vital. Save copies of emails, notes of conversations, and any disciplinary notices related to the adverse action. Timing matters a lot. If the negative action happens soon after your report, it supports the idea that retaliation was involved. Also, if your employer has a history of punishing employees who blow the whistle, that pattern can be used as evidence. From a legal point of view, you need to show it's more likely than not that retaliation happened. This is called the preponderance of the evidence standard. Laws like the Whistleblower Protection Act and the Sarbanes-Oxley Act requiring you to establish this causal link to succeed. In simple terms, your goal is to gather credible proof that links your protected report to the negative action. Whether it's direct proof like emails, circumstantial clues like timing, or witness statements, all these pieces work together to build your case. Keeping thorough records and understanding the legal standards can make a big difference in proving retaliation and protecting your workplace rights.